Brenay has filed a motion to extend time in Devon's Alimony and Equitable Distribution Lawsuit. Two new filings have hit the Wake County docket. The first, a notice of appearance by, you guessed it, Attorney Hamilton, who is now representing Brenay in this case as well. An interesting development considering the previous claims about financial strain, but it is absolutely her legal right to retain counsel. The second filing is a motion to extend time to give an answer on Devon's amended complaint. Now, I know what you're doing. I need you to put the pitchfork down and the chanclas. You do not write at dawn. We're going to break this down calmly. As always, I am a certified law nerd, bona fide non-attorney. This is not legal advice. This is just my interpretation of what I'm reading in the public record. Let's begin. In this motion, filed last night around 9 p.m., Brenay, through Attorney Hamilton, states that she was served with the amended complaint on or about January 28th of 2026. Now, if you remember, this amended complaint dropped in mid-December of 2025, but after several failed attempts to complete service, an alias and pluri summon had to be issued in order to escalate service, for lack of a better term. She was finally served via the sheriff on January 28th, and that service date matters because deadlines in civil litigation run from the date service is completed, not from the date the complaint is filed. Now, this motion cites Rule 6b of the North Carolina Rules of Civil Procedure, so of course we pulled it up. Rule 6b allows a court to extend a deadline if the request is made before the original deadline expires. So let's look at the timeline. The amended complaint was filed December 16th, service was completed January 28th, this motion was filed February 19th. That puts it within the 30-day response window. And remember, we still do not have an answer on file in this case. When a complaint is filed in a civil lawsuit, the defendant is required to file an answer responding to those allegations. We saw that already play out in Devon's separate lawsuit against Tim. This motion is asking for more time to prepare that answer. So now that Attorney Hamilton has been brought on board in this case, this move is not very surprising. If I'm being completely honest, it's what lawyers do. They buy themselves time. Time to get up to speed, review evidence, and assess strategy, especially when stepping into a case that includes allegations of marital misconduct, income disputes, and financial claims. Those are heavy allegations, and that's going to require some litigation. So, what does this mean for the March 23rd hearing? Well, if this extension is granted and the response deadline is pushed way too close to the hearing date, could we potentially see a motion to continue or delay the trial? Could. Not will, could. And honestly, that's not really unusual for cases like this. However, I do need to remind you this is simply step one. This is a request to the court to allow them more time to file an answer. So this is pretty standard procedure here. Procedurally speaking, Attorney Robin is not automatically required to respond. She could consent, or she could just not respond at all and let the court rule. Now, if for any reason she has an objection, because let's say this would cause prejudice as it's too close to the March 23rd hearing, we could see her file an objection. As always, we'll keep an eye on the docket. I'll catch you in the next one.